Our next presenter, Michael Gerrard, will talk about climate litigation in the U.S. And Nicholas de Sadalier, the one after that, will talk about litigation and legislation in the EU. So they're kind of a pair in a way that fit together pretty well. Michael Gerrard is Andrew Sabin Professor of Professional Practice at Columbia Law School. He teaches courses on environmental law, climate change law, energy regulation, and he founded and directs the Sabin Center for Climate Change Law there. It's one of the biggest, kind of most important repositories of information. They have all kinds of databases on regulations and litigation and such. It's a really important facility for kind of worldwide climate change law. So he was the founder of Columbia University's Earth Institute and chaired it from 2015 to 18. And he's a prolific writer on environmental law and climate change with several books and many articles, like 13 books. So you can see a little bit more of his bio on our webpage at Cool World Institute, but I'm going to turn this over to Michael right now. Take it away.
Dean, thank you very much. It's a pleasure to be with you here virtually. Can you see my slides? Are they up? Okay. As Dean said, I'm going to talk about climate change litigation in the U.S. As he mentioned, we have databases on our website that attempt to capture all of the climate change litigation in the United States, and another that attempts to have all the climate litigation in the world outside of the United States. So you can find that at www.climatecasechart.com. And we continually update this. We also put out a free monthly update with all the new cases. If you want to get that, you can go to the Sabin Center's website, which is www.columbiaclimatelaw.com. So when we look at all the cases on climate change in the world, we have found a total of 1,452 cases around the world. The US is by far the champion. We have far and away the largest number of climate cases in the world. Australia is a very distant second. The UK is a very distant third. We're defining a climate case as a case where climate change or greenhouse gases are an explicit subject of the litigation. It does not include cases that may have been brought with a motivation to fight climate change, but don't specifically talk about it, such as the many cases of fighting coal-fired power plants, but that don't mention climate change explicitly. In the US, the largest number of cases are brought under the National Environmental Policy Act, NEPA, the US federal law that requires environmental impact statements for major federal actions that could significantly affect the environment. There's also a very large number under the state laws that are their state's equivalent of NEPA, and by far the largest number of those cases is under the California equivalent, the California Environmental Quality Act. We have quite a few cases under the Clean Air Act, and I'll be talking more about that in a minute, under the Endangered Species Act, and a whole variety of other theories. It's a rich area of litigation. So starting with the cases under the US Clean Air Act, the most important climate change decision ever issued by the courts in the US is Massachusetts versus EPA, which was a 2007 decision of the Supreme Court, which held that the Clean Air Act authorizes EPA to regulate greenhouse gases. It said that greenhouse gases count as air pollutants within the meaning of the statute, and that EPA has the power to regulate them. This decision was issued during the George W. Bush administration, which didn't do much to carry out the decision. But as soon as President Obama took office in January of 2009, he told EPA to begin acting on it. And so in late 2009, EPA issued an endangerment finding, which was the formal finding that it needed to make in order to begin the regulation of greenhouse gases. Having issued that, EPA and the National Highway Traffic Safety Administration then issued rules concerning greenhouse gas emissions from passenger vehicles and fuel economy from passenger vehicles. The Massachusetts versus EPA lawsuit had been brought specifically on the question, does EPA have the power to regulate greenhouse gas emissions from motor vehicles? Supreme Court said yes. So EPA issued, and the Transportation Department issued regulations that greatly tightened the motor vehicle standards going out to 2025. And these are standards that, as David just mentioned, the Trump administration is trying to roll back. Having issued the motor vehicle rule, EPA then proceeded to issue regulations on stationary sources, power plants, factories, and so forth, under the Prevention of Significant Deterioration Program, which is a particular program of the Clean Air Act. All of this was challenged in court. There were more than 100 lawsuits that were brought challenging all of these actions. It ultimately went up to the Supreme Court, and at the end of the day, almost all of it was upheld. The endangerment finding was upheld. The motor vehicle rule was upheld. Most of the Prevention of Significant Deterioration Program was upheld, except for the portion that would newly require air pollution permits for stationary sources that did not otherwise require permits. Those are the newly regulated sources. EPA then began using a different part of the Clean Air Act to issue other regulations called New Source Performance Standards. And this ultimately led to the Clean Power Plan, which was primarily aimed at reducing greenhouse gas emissions from coal-fired power plants. In February of 2016, the Supreme Court stayed that plan. It said it couldn't be enforced. This was very disheartening to EPA and to environmental advocates who have been working for years on trying to get that through. But the Supreme Court stayed that plan. The U.S. Court of Appeals for the D.C. Circuit heard argument a few months later in September of 2016 on whether the plan was lawful. But in November, Donald Trump was elected president. He had pledged in his campaign to kill the Clean Power Plan, which he's moved forward with doing. And the DC Circuit never issued a decision. So we still don't know whether the Clean Power Plan would have been lawful. But the fact that the Supreme Court stayed it is not a good sign. So the Sabin Center has been tracking all of this climate litigation, and a year ago, last June, we came out with a report on the climate change litigation under the Trump administration. During the Obama administration, much of the climate litigation that was happening were suits by industry and by the states that oppose greenhouse gas regulation, typically led by Texas, Oklahoma, and West Virginia. Challenging what EPA was doing. When Trump took over, it flipped. The Trump administration has been systematically trying to roll back Obama's climate and other environmental regulations. And so the litigation was mostly brought by proponents of strong regulation, on strong environmental regulation. So we counted it up, and in the climate cases, we divided them between those, the pro cases, the cases that were for climate regulation, and the con cases, the cases that were against it. And so we see the largest number of cases were the pro cases brought by non-governmental organizations, and then by governments, mostly states and a few cities, trying to uphold the environmental regulations. As David alluded, the Trump administration has done a really terrible job in its efforts to try to scale back or repeal or put a hold on these regulations. This is a list of many of the rules that the Trump administration tried to eliminate or roll back or stay. And they had to go, as David mentioned, through the Administrative Procedure Act, through a detailed process of putting out a draft rule and opening it up to public comment, considering the comments before issuing the final rule. And so this shows how far each of these proposed rules got in the process, generally not very far. Each of these X's is a case where they failed in court, where NRDC or EDF or with Justice or states or other plaintiffs succeeded in stopping the actions, the attempts by the administration to roll back these regulations. This is a partial list of the Trump deregulatory actions that have been defeated in court. Now, not all of these are final defeats. Many of them are that the administration was stopped and sent back often to square one to go through the process. And in some instances, they would be able to go through the process and survive. These are mostly procedural issues that they've been caught on. Some are substantive. And so there are efforts to delay EPA methane standards for oil and gas and delay a Bureau of Land Management rule on methane leakage from oil and gas wells, and endangered species protections, energy efficiency standards, oil and gas drilling, lifting the moratorium on coal leasing, weakening regulation of hydrofluorocarbons. And the most recent decision was yesterday. There have been these two cases challenging the EPA's decision that in its scientific advisory boards, it was going to kick out any scientists who had received federal grants, which is most legitimate scientists, and replace them with mostly industry people. So these two decisions in the last week have said that was no good. So this is one kind of very active climate litigation that is continuing to go on in the US. A completely different line of cases was inspired by Professor Mary Wood of the University of Oregon Law School. The public trust doctrine stems from Justinian law and the basic idea that the government holds in trust for the public certain aspects of the natural environment like forests and rivers. Professor Wood put forth the theory that this public trust doctrine also applies to the atmosphere. Based on that, an organization, a nonprofit organization formed in Oregon called Our Children's Trust, which began bringing lawsuits all around the country against state governments and a couple against the federal government, saying that the government has an obligation to prevent dangerous climate change, because that's a breach of the public trust obligation of governments to protect the atmosphere from damage. Most of these lawsuits were dismissed. In most cases, the court said either that the public trust doctrine does not apply to the atmosphere, or that the plaintiffs did not have standing to sue because they were not affected by climate change differently than everybody else, or that dealing with this was not a proper role for the courts, that the state legislatures and governors should play that role. So most of them were dismissed until we got to the very famous Juliana case, brought by 21 young people in the U.S. District Court in Oregon. This is a rally that they had in front of the courthouse. This is Julia Olson, who is the lead lawyer for the plaintiffs. This fellow in the back with the hat is Jim Hansen, a very famous climate scientist who played an important role in the case. The lawsuit was seeking this relief: order the defendants, order the federal government to prepare and implement an enforceable national remedial plan to phase out fossil fuel emissions and draw down excess atmospheric CO2 so as to stabilize the climate system and protect the vital resources on which plaintiffs now and in the future will depend. It's a very, very broad prayer for relief. Case was filed in 2015. On November 10th, 2016, which happened to be 2 days after Donald Trump was elected president, the trial level judge denied the motions to dismiss by the federal government and said the case should proceed. The next step was for the Department of Justice, the lawyers for the US government, to answer the complaint. A few days before Trump was inaugurated, the Department of Justice, still under the Obama administration, answered the complaint and admitted many of the allegations in the complaint. Allegations that human activities were causing greenhouse gas emissions, which were causing climate change, and that climate change could have a very negative impact. The Department of Justice did not admit that it was the fault of the federal government, but they did admit many things. Various fossil fuel companies had intervened as defendants in the case, initially to try to make sure that their voices were heard, but after the case got going and the plaintiffs started seeking discovery from them, they dropped out of the case, and they were now more satisfied that the Trump administration would adequately represent their interests. The case bounced back and forth for several years between the trial court, which wanted to have a trial, and the Department of Justice tried to stop the trial at the Ninth Circuit Court of Appeals and the Supreme Court. Ultimately, the Ninth Circuit Court of Appeals agreed to hear the case. Meanwhile, because the trial had been scheduled, each side indicated who its expert witnesses were going to be. The plaintiffs had a lot of expert witnesses to talk about the adverse effects of climate change, about how the fossil fuel system could be changed to help fix the problem, about the particular injuries that the named plaintiffs, these young people, had faced, about the economic benefits to the country of doing all of that. The defendants, the US government, had a much shorter list of experts. They denied that the individual plaintiffs actually were sick as a result of climate change, and they said that it was not the US government's fault. They did not contest the underlying science of climate change, and in fact, in none of these cases have litigants contested the underlying science of climate change with any success at all. No court in the world actually has questioned the underlying science of climate change. The Ninth Circuit came out with its decision in January, a 2-to-1 decision that dismissed the lawsuit. The majority opinion, the two judges in the majority, absolutely agreed that climate change is happening, that it poses a grave threat, and that if it is not addressed, it endangers the nation. But they said, it's not our job. They said that even though the political branches, Congress and the president, may have abdicated their role, we don't have the power to step in. The dissenting judge disagreed, and in a very eloquent opinion that I commend to everybody, said that when the seas envelop our coastal cities, fires and droughts haunt our interior, and storms ravage everything in between, those remaining will ask, why did so many do so little? So the case was dismissed. The plaintiffs have filed for en banc review, which means that they're asking all of the entire panel of all the Ninth Circuit judges, active judges, to rule on it. We'll see what happens with that. Another line of cases, completely different line of cases, are brought under the public nuisance doctrine. These are lawsuits for the most part, against fossil fuel companies that have been seeking money damages from fossil fuel companies because of the damage that greenhouse gas emissions caused by fossil fuels have created. Now, there's a very important Supreme Court case under the same theory that was actually seeking not money damages, but injunctive relief. It was brought by Connecticut and New York and several other states against several electric utilities, asking for an injunction that they reduce their emissions from the coal-fired power plants. The Supreme Court unanimously ruled that this case couldn't go forward under the federal common law of nuisance because the federal common law of nuisance is to fill in gaps in the law, but the Clean Air Act, as interpreted by the Massachusetts case, allows, gives EPA the power to regulate greenhouse gases. So there's no gap. That it's in the federal government, it's the sole job of the EPA to regulate greenhouse gases. So that lawsuit was dismissed. There was another lawsuit that was pending around the same time for money damages. The village of Kivalina, Alaska, is in great danger from ice melt. They sued Exxon and other fossil fuel companies for the money to relocate their village. But the Ninth Circuit ultimately held that the injunctive case I talked about a minute ago also applied to money damage cases. And so that case couldn't go forward under the federal common law of nuisance. These decisions, however, left open the question of whether state common law nuisance could be used on climate change. And nothing happened for several years until 2017. And in 2017 and 2018, and then one a few weeks ago, a total of 15 lawsuits have been filed under state common law nuisance theories, mostly brought by cities and counties, one brought by a state, Rhode Island, all of them against fossil fuel companies seeking money damages for seawalls and other efforts to adapt to the climate change that the complaints allege is caused largely by the emissions from the fuels extracted by these companies. And so these lawsuits raise different kinds of environmental damage that they allege. They all sue Exxon. Most of them also sue Chevron and BP and Shell and ConocoPhillips and some others. They're under a variety of legal theories. You know, they all raise public nuisance claims and also a number of other common law claims. The fight that is going on now in most of these cases is, do they belong in state court or federal court? I mean, two of the cases have been dismissed at the trial level, one in New York, one in California. Those have been, the appeals and those have been argued, but in the rest, there are fights going on whether they belong in state court or federal court. All of these cases are largely relying on a series of studies led by a fellow named Richard Heady, who took a look at the history of of fossil fuel extraction and at companies and their corporate predecessors and so forth, and came up with charts like this saying which companies are responsible for what percentage of the fossil fuels that have been extracted over the last century and a half, and what percentage of the greenhouse gases in the atmosphere are responsible for, each of these companies is responsible for. So that's the theory on which these cases, on which the damage allegations are based, and that's going to be ferociously litigated, certainly if the cases survive the current motion practice. There's also going to be a lot of litigation about whether the extraction of fossil fuels was unreasonable. It's a difference from tobacco is that, of course, although the plaintiffs were successful in the tobacco cases, society doesn't rely on tobacco. Society has been relying on fossil fuels, and so there's a lot of dispute about, there will be a lot of dispute about that. Another issue that will be in dispute will be the supply chain. So the oil companies extract the oil, but they don't burn it. It gets burned, they burn a little bit of it, but for the most part, it gets burned in motor vehicles that are made by the motor vehicle manufacturers, then driven by consumers. So where in the supply chain does liability attach? Where was there improper conduct? Similarly with coal. The coal companies mine the coal, but the power companies burn it. And people then use the electricity. Where along this does the liability happen? Another line of litigation is securities fraud. There have been investigations by the Attorneys General of New York and Massachusetts saying that Exxon in its securities disclosures was deceiving investors and the public about climate change. Exxon brought several lawsuits to try to shut down those cases. None of them succeeded. The cases have been able to go forward. The New York case against Exxon went to trial before a judge, and the judge, after the trial last December, dismissed the lawsuit. He found that the New York Attorney General had not made out his claim. The Massachusetts case is still pending, and there's also a pending private securities lawsuit in Texas. Another line of cases was brought by an NGO in Boston called the Conservation Law Foundation, saying one of these cases was against Exxon, the other against Shell, saying that not against them because of fossil fuel extraction, but saying that their oil tanks were not protected enough from storm surge or extreme weather events, and that violated the Clean Water Act and the Oil Pollution Act. Just a couple of weeks ago, the court in Boston put that case on hold, saying that it's really EPA has primary jurisdiction over this, and he's going to wait. The court is going to wait until EPA acts on whether the preparations by Exxon for extreme weather events are adequate. The other case was brought against Shell in Rhode Island and is still pending. And finally, there's going to be a lot of litigation about the impacts of climate change itself, a lot of litigation after Hurricane Harvey hit Houston and the liability of the Corps of Engineers for the way it operated various dams and so forth. So I think that in the years to come, as climate change gets worse, we'll have more litigation against any variety of defendants, not only the fossil fuel companies, but people like architects and engineers and builders and so forth for not taking adequate precautions against climate change. So I'm going to stop here and let me look at questions that have come up. At the end, could we share the citation to the Climate Change 2014 peer-reviewed article again? If you're talking about the Richard Heady article, I will send around that citation. There was a question before, which I think David punted to me. What is the impact of greenhouse gas emissions on air quality? Well, partly, it itself is a greenhouse gas levels in the atmosphere themselves are a matter of air quality. But there are some of the greenhouse gases, methane and nitrous oxide, in addition to being greenhouse gases, have other negative impacts on through atmospheric chemistry on what we breathe. Carbon dioxide at the levels we're talking about is not harmful to breathe. Its impacts are global through its effect on climate change, but methane and nitrous oxides can have local impacts. So I'm not seeing any other questions, and I will turn it back to Dean.
Okay, let me just do that. Thank you, Michael. That was a great presentation. I think that was provided a lot of information for the people who are participating in this. So thank you so much.